Welcome back to Good Law, Bad Law. Today we're talking about the Equal Rights Amendment. You heard right, the ERA. Many probably think this is just a dusty old piece of history, but the truth is that it's current, it's happening, and one state away from being ratified. There's a lot more to the story, but thankfully my guests Lucy Beard, director of the Alice Paul Institute, and Roberta Francis, who has been working on the ERA for the last 4 decades. And I talk about this, what the history is, what the current status of the ERA is, now more relevant than ever, and what the future holds for this important debate and this important issue. Should women be recognized in the Constitution, guaranteed explicitly equal protection under the law? You won't want to miss this episode. Today on Good Law, Bad Law, we're talking about what? The Equal Rights Amendment. That's right, the Equal Rights Amendment. Some, and not many, might think that that's just a dusty old part of our constitutional history, but my guests today, Lucy Beard, who's the executive director of the Alice Paul Institute, and Roberta Francis, who is the founding chair of the ERA Taskforce of the National Council of Women's Organizations, are going to explain to us why that is not the case, why the ERA is alive and well and closer to being ratified than you might think. So first of all, let me warmly welcome both of you, Lucy and Bobby, to the program. Thanks so much.
Yep, thank you.
Hi, thanks for having us.
The news that brings us to this subject was certainly surprising to me. And I'm deeply interested in the Constitution as a lawyer and as a former journalist writing about these topics. But I didn't know, and I think was too little reported, that just a few months ago in May, the state of Illinois became the 37th state in the country to ratify the Equal Rights Amendment, which was first passed by Congress way back in 1972. So we need to talk about that, understand the background and the history, and how we are this close in this moment when all that we know is going on in Washington over the confirmation of Judge Kavanaugh. Why the ERA is more relevant perhaps than ever. And so I'm really grateful to both of you for helping us understand that better and to talk about it with me today. So first of all, I thought it would be great if each of you could just give us a bit about yourselves. Lucy, perhaps starting with you, and of course you'll need to tell us who Alice Paul was.
Right. Happy to. Well, first about me, Lucy Beard. I'm the director of the Alice Paul Institute, and I've been here on and off for the last 25 years. Alice Paul led the final fight for women to get the vote. She was considered the radical side of the suffrage movement. These were the women who picketed in front of the White House, Woodrow Wilson's White House, that is, who were jailed for that picketing and then went on hunger strike and were even force-fed. And it's a small chapter in American history that is little known because, in my view, we do tend to write our radicals out of history whenever we can. And Alice Paul, in her day, was considered radical in the suffrage movement. And she basically was written out of history. She then went on. Most people, after women won the vote, felt that the battle was won. They were done and they went home, but not Alice Paul. She felt that the battle was just the first step.
And that was just so people know, that was the 19th Amendment, which
yes, that
became
was the 19th Amendment. Yeah.
And what was that? Was that 1920?
August 1920, August 26th, okay. Women's Equality Day, it's always been called. But she then turned her attention because she fully believed in the power of the Constitution, that the Constitution is what makes America a nation. We are brought together by our code of law, not by our ethnicity or our race or our gender or our religion, but really what makes an American is following the Constitution. And she felt strongly that when 51, what is it, 52% of the population is not protected and represented in that Constitution, that we have a fundamental inequality in this country. So, she had been the energy behind the idea of getting the vote for women through a constitutional amendment. That she had really spearheaded that effort in the last 15 years of the movement. So she wanted to use the same strategy again in order to ensure legal equality for all, regardless of our gender. And she composed the Equal Rights Amendment. And it was entered into Congress in 1923 for the first time and re-entered every session thereafter. Every 2 years, it's reintroduced. And she worked for the rest of her life from 1923 until her death in 1977 for an Equal Rights Amendment to the U.S. Constitution. Now, she also worked on the international stage and had a huge impact on constitutions of other countries all over the world. Germany, Japan, all of the African democracies have a gender equality provision in their constitution. And that's as a result of her work on the international stage for this concept. But it has not passed in the United States.
Well, she did. So she lived long enough to see the ERA passed in Congress, but not long enough to see it actually ratified.
Right. It was ratified in 1972. And I don't want to take too much of Bobby's story here, but it was ratified in 1972 and was given a limit of 7 years, which was later extended to 10 years for ratification. And I think, Bobby will correct me if I'm wrong, but I think it may be the first amendment that was given that kind of time limit. And Alice Paul herself knew that that was probably scuttling it, that it would not pass in less than 10 years.
Right, and we're going to talk. We're going to talk later in our conversation about that time limit and whether actually it's valid or would need to be honored if we would get just one more state to join the other 37 who have approved this to be an amendment. But tell us.
I'm sorry, but before we move on, Aaron, I just wanted to put a friendly amendment to what Lucy said. It was passed by Congress in 1972, but sent to the states then. It wasn't ratified then. The ratification is the final result when 3/4 of the states approve it. So and in fact, the first time limit imposed on amendment was on prohibition, which was a political ploy. And then Congress didn't put one on the 19th Amendment, the next one proposed, but then it has ever since then. So it's kind of become just a protocol kind of thing. It's not required in the amendment process by the Constitution itself.
Right, and we'll get to this later, but this question of whether that time limit is valid or enforceable or would even be recognized by the Supreme Court should one more state step up and ratify or vote to ratify the ERA. We'll see. That'll be an issue that'll be in front of the Supreme Court. But before I turn to you, Bobby, for your background, Lucy, so the Alice Paul Institute then does what? What is the work of your organization?
Well, our organization was created in 1985 by a group of women who had been ERA activists in the 70s and 80s until it fell to defeat in 82. And they wanted to do something tangible to honor Alice Paul's legacy, her work for gender equality. And in 1990, they purchased her childhood home, an old farmhouse in Mount Laurel, New Jersey, where she was born and raised. Her family owned the property for 80 years. And we saved the house, not so much, we wanted to save it as a historic site because we all believe strongly that you value what you save and you show what you value by what you save. And women's history is undervalued and is not saved often enough. So this organization was really spearheaded the last 30 years of a growing awareness of women's historic sites and that their value and how much we need to save them. So they saved this place, which is called Paulsdale. It's 6.5 acres, and it's a 200-year-old farmhouse. It is a National Historic Landmark, one of the less than 5% of National Historic Landmarks that honored the work and achievements of a woman. And they saved it not just to create a historic site, which it is, and it's open to the public for tours. There's one going on downstairs right now as I'm speaking.
Okay.
But also as a leadership development center, as a place to keep Alice Paul's work going. And this was in 1990 when they decided this. This was a very new concept, but many historic sites today are attempting to justify their existence through a contemporary purpose. And we were on the leading edge of that movement. So this morning, right now, there's a group of older women who are here for a tour, and tonight there will be a group of 25 high school girls here learning leadership skills, learning about Alice Paul's legacy, learning the importance of gender equality guaranteed in the law, and getting ready to attend a program at the United Nations next week on the International Day of the Girl. So we have this bifurcated mission and do a lot of different things here. But I would encourage anyone listening to look at our website, alicepaul.org, find us on Facebook, Alice Paul Institute, and get a taste of what is happening here, because it's very compelling work.
That sounds great. I know I mentioned this before we started. I've got daughters and I've got a stepdaughter, and I'm going to make sure that they check it out. I know they'll want to.
Yep, yeah. Send them out.
Bobby, tell us about yourself and the work that you've done on this issue over what I understand is a couple of years.
A couple of years times 40, I believe, or no, a couple of years times 20 anyway.
Right.
But thanks. I live in Chatham, New Jersey, and have for a long time been very supportive of Alice Paul Institute and Paulsdale and so on, and have at this point become so-called ERA education consultant for Alice Paul Institute.
Yes.
So I'm in that capacity right now, but had done a lot of work over those decades, including being the founder of the ERA Taskforce of the National Council of Women's Organizations, which was based in Washington. It operated for some decades itself and is no longer so active. But at the local level is how I got involved. I was the local League of Women Voters president here in Chatham in the late 70s, I guess, with 2 young kids at home. And somebody asked if I had information about the Equal Rights Amendment. This was at the time the ERA had been voted out of Congress, was being ratified by a number of states. In fact, it came barreling out just as the 19th Amendment had in, I guess it was 1918, it came out of Congress. And then in both cases, there are amazing parallels. In both cases, the opposition to equal rights for women came out of the woodwork and raised all kinds of, in fact, similar questions, up to and including it would take women off their pedestals, et cetera, and destroy the family and this and that. But there really were, in both cases, strong economic reasons behind it, social, cultural, religious, psychological. There are all kinds of reasons for opposition to these advances. So anyway, I was just going to say that's where I got started on the ERA and had my feminist clique, if you might call it. So ever since then, I've been keeping on.
Well, I just wanted to jump in because what you were just describing, concerns about the impact on the family and taking women off their pedestal, and whether women even had the mental capacity to handle this.
Absolutely.
I couldn't really tell whether you were talking about arguments that were made back at the time that our country was talking about giving women the right to vote, or whether you were talking about the Equal Rights Amendment many decades later. And I think there you have it. I mean, that
yes, that's right. And because they were, I have said it's like somebody pulled out the old script and didn't even bother to change it much when they pulled out the 19th Amendment script and said, "Oh, let's do this for the ERA." It is astonishing.
Well, this is really astonishing to me, because we know that, and just in the few minutes we've been talking so far, we've established that the ERA passed Congress, but has not yet been ratified, and therefore it is not part of the Constitution. This very simple language that states in Section 1, language that Alice Paul wrote. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. A very simple declaration. And we know, and now our listeners know, that this is not yet part of the Constitution. But when you look at polls of what people think, and you cite some of this, Bobby, in some of the materials that you've put together on this, an overwhelming majority of Americans think that we already have an Equal Rights Amendment in the Constitution. So there's this great disconnect between what people think and what is.
Right.
Why do you think that is?
Well, I don't even know what number one reason would be, except people are so um, engaged with all of the things that we know keep us all running around, and based on our own interests and our needs and what comes up in our lives, that I think people who um, care about, learn about, and get interested in equal rights for women, equal status, etc., are the ones who understand that we don't have it. And most people think, oh, there have been tremendous advances in the last 50, 60 years in the status of women, women's rights, etc. And so they assume that it's a kind of wide open field for those advances. And in fact, those of us who have worked on the Equal Rights Amendment and its the parlous lack of it in our Constitution, when it is, as Lucy said, in so many other constitutions in the world, imperfectly implemented, of course, in virtually all countries, but at least there is that avowal of equal rights on the basis of sex. Um, the people who think that we have that guarantee just sort of de facto because they've seen all the advances uh, don't know until they're actually told or understand and discover that we've done these in spite of not having an Equal Rights Amendment underpinning it. The foundational, I say law, but I mean a constitutional guarantee, getting it in the Constitution, that's the foundation for not only having these advances guaranteed, making sure that we don't have them removed, set back. I mean, we know in the recent years we've been talking about is birth control something that we want to guarantee legally. I mean, issues that we thought were long since taken care of. And in fact, the several Supreme Court decisions in the 60s about birth control for married and then unmarried people were not something anyone thought would be revisited. And yet, without this additional guarantee of equality of rights under the law, thank you for reading it, shall not be denied or abridged, having it in the Constitution is the sine qua non for not being set back.
Well, also, I mean, those Supreme Court decisions that you're referring to from the 60s and then in the 70s and, other reproductive rights decisions,
right,
including Roe v. Wade, the Supreme Court didn't have an ERA, didn't have equal protection on the basis of gender to rely on. The 14th Amendment, which talks about equal protection, doesn't by in any specific way include women.
Right.
And so they had to turn to other ways to find a right for birth control and a right for other reproductive rights, including abortion. They had to find a right in the language of privacy.
Right.
And we know that
Correct.
we continue to feel very uncertain about the future of Roe versus Wade, for example, because there is this ideological, judicial, legalistic debate about whether that's a valid basis for those rights to be found in a right of privacy. So these, I think that's a good case for trying to understand what the Constitution really does say and what it doesn't say right now.
Right.
So,
You're just reminding me. I think. Go ahead. I'm sorry.
No, go ahead, please.
Well, I was just going to say around Roe v. Wade. I've done some work on this too, and I am fascinated by the fact that the decisions we were alluding to in the 60s, Connecticut, was it
Griswold
Baird?
versus Connecticut. Yeah.
Griswold versus Connecticut, and then Baird versus, was it Massachusetts? But these two decisions around the ability to have access to birth control, contraception, without government interference, set the stage for the right of privacy, in quotes, it's not that Roe v. Wade was written out of, created out of whole cloth.
Right. That is true.
The support of these decisions in the 60s around access to contraception without state interference are the underpinning, I should say,
Yes.
for the quote right of privacy in Roe v. Wade. And I think listeners should understand that doesn't just mean, oh, I have the right to do what I want in my own home, sneaking, blah, blah, blah. Right of privacy means, and correct me if I'm wrong, Aaron, the right to do something free of governmental interference.
That's absolutely right. And Justice Kennedy was a big, proponent of that, not just in the abortion-related decisions that he was a very crucial part of, but in other areas. He was the principal author of the Obergefell decision on same-sex marriage, and there's a strong current that runs through Supreme Court decisions before Roe versus Wade, certainly in Roe v. Wade, and then in many cases after, that talks about this sort of this circle around an individual that within that circle are the most fundamental and personal and intimate choices and decisions that a person can make, and the government should not tread past that point. Should not tread on those fundamental, individual, private, personal, intimate liberties.
Right, and I think I don't know if it's expressed exactly this way in the decision, but it's that right is the right of a woman to determine whether or not to bear a child.
Right, that's right.
And so, and without spending, more of the ERA time on this, but they are interrelated, but not in a way that opponents challenged the ERA and opposed it by saying it would mean abortion on demand. No, it really is not in and of itself on the face of it and in the direct application of legal principles. It's not very much about reproductive rights, except in the sense, which has not been established legally, that for a woman to have the ability to exercise her equal rights, she also must have the ability to determine personally, under her right of privacy, whether or not to bear a child. But it's not something that the ERA is integrally involved in legally.
Well, and again, the ERA really is about equal protection under the law. This is something we talk about all the time. Many speeches from politicians on all sides of the political spectrum will talk about that being the defining characteristic of our Constitution, that we are all equal in the eyes of the law. But of course, there is a history that has been evolving here. I mean, the Constitution, when first passed in 1789, of course, didn't recognize racial equality. We had to have a civil war to get to that point, and it didn't recognize the rights of women either. And that's why the right to vote in the 19th Amendment was so radical, as you've said, Lucy. But let me come back to you, Lucy, on that, because I want to get us to the point where we can understand where we are today with the Equal Rights Amendment. And to do that, I think I want to turn back to you and the story of Alice Paul and the ERA, and why she devoted her life to this and felt it was so important. You say she was a radical in the 19 teens and 1920s, but yesterday's radical may be today's visionary. So how did she see, and why was this seen as something necessary to recognize, not in a state law here and a state law there, but in the Constitution? Why was that something so important to have?
Right. Well, I think she felt that our foundational document, the Constitution, should reflect our population, and felt strongly that it didn't, that it was representing men and not women. Women are not protected under the Constitution, as you were both just discussing. But she also, I think she was an astute politician or political strategist, and the tactics she used in the suffrage movement were very effective at getting publicity for the cause and keeping it on the front pages of the newspapers. And she turned those tactics to a much longer, probably harder to grasp campaign. I think the Equal Rights Amendment was always something that was just a little more, I don't know, academic than voting. Everyone could kind of understand voting. But the idea of, no, we need this in the Constitution for legal reasons is just a step higher in terms of what the average person walking around will understand and comprehend and act on. So I think she knew she was in for a longer campaign than what she had been involved with suffrage. In the end, it is taking longer than suffrage took. We got the vote in 75 years, and we're almost up to 100 years for the ERA. And then she was very, I hate using this word, but she was more or less marginalized or sidelined in the 40s and 50s, I would say. And I'm hoping that Bobby will come in with another friendly amendment if I'm misspeaking here. But I think that she stayed single-mindedly focused on gender equality guaranteed by the law. And as the second feminist movement, the second wave of the feminist movement was really building steam in the 60s and 70s, it was being translated to, I'll call them domestic issues like childcare, like pay equality, like all these different things in your daily life that people might find easier to relate to, but they couldn't relate that to the ERA. I think today people are starting to figure it out. And are realizing, oh, there's a direct connection between my legal rights and the fact that I get paid less because of my gender, or the fact that I don't have access to quality child care. So I think we are starting to make that case more clearly for people. I don't know that Alice Paul ever did that very effectively. She was frustrated in the second wave. She was also, I'll point out, getting up there in years and probably a little tired, but she was a little frustrated, saying that they were diluting their efforts by focusing on so many different issues. And if they would just focus on one, gender equality guaranteed in the law, the other things would fall into place. Mm-hmm. Because once you have that guarantee, then you have your day in court, literally. You can go to court and claim gender discrimination if you have a foundation of law for it.
I think, well done. No friendly amendment per se, but I'll just add a few thoughts. That, in fact, after the ERA, after, I should say, the vote first was attained in 1920, then some people did just say, we've done it, we're going home. Others said, now we have to keep working on things like what they had at the time already begun, and that was some protective legislation, labor laws for women, limiting number of hours and certain stipulations that women couldn't work at XYZ under conditions. And so there was a split almost immediately when the National Women's Party, which Alice Paul was the leader of during the suffrage struggle, proposed the Equal Rights Amendment because there was the fear that all of their work on protective laws to make working life better for women would be undercut, have to be done away with. I keep wondering why they also, the argument wasn't made that men deserve these protections too. Let's make it gender equal and no man can work more than 50 hours a week or whatever it was at the time. But in any case, there was a split within the progressive women's rights community over whether we want this Equal Rights Amendment or not. So that persisted for a number of years. And then the World War II, and I'll call it the doldrums, there were, the populace was otherwise engaged. And it was in the 60s, I believe, when I would say the current awareness of the connections that Lucy described first started growing, and that's when the ERA got a lot more support, got out of Congress in 1972, went to the states and got 22 ratifications within the first year of the necessary 38. The 35 number comes in next, because after a few years of its barreling through so that it looked like it would be ratified, within some reasonable number of months, the opposition surfaced, and it was, again, some of it was cast as social, the women don't want this, et cetera, it's going to challenge destroy various things, when really behind it was a very, very long-lived traditional opposition to equality for women. And it's partly
And
economic and
why?
so on.
And why? Because and I want to, maybe we have to go back to that time period, and we're looking
Hmm.
as we talk today through 2018 eyes, but about, back in the 1970s, you had so many social changes that had already taken place. You mentioned World War II. I mean, Rosie the Riveter.
Hmm.
Women had to go into the workforce as to fuel the economy, while the men were
Yep.
overseas,
Yes.
fighting for freedom. That was a bit that brought about a tremendous social change. You had you know, the the Supreme Court's focus on individual rights in a way that it hadn't
Right.
up until then, and some of the decisions we've already talked about, the civil rights movement expanding,
Yes.
civil
In the
rights
60s, right?
for Black Americans, and then the rise of the women's movement. So, what what is the opposition? What is wrong through the eyes of 1970s
Yeah. Well,
states confronted with the opportunity to ratify this amendment? What is the opposition?
I forget which law of Newton's is that for every action there is an equal and opposite reaction. Some of it is and it's not equal and opposite literally in this social field, but I use the image or metaphor in my mind, image of a spiral going up, a coil, and I think that's the way advancement works politically. You go forward, and then there's stuff pushing you back, but you're one level up, and then
Hmm.
you go forward, and you're pushed back, but you're a level up, and I like that image. It helps me feel like it's an explanation for what we face. Because when I had my click around the ERA in around 1977, I asked perhaps the most naive question of my life. I said, "What's to argue? Equality of rights shall not be denied on account of sex. What's to argue?"
Right.
And then when I started getting into it and got angry that they'd used the same arguments, almost the same arguments around suffrage, and then you look at back around, and again, it's not just women and men, or it's not just race or anything, but you look at the arguments against abolition. We live in a world where there are a lot of people, and there's a lot of energy in the direction of progress and equality and justice and so on. And there's an awful lot of energy against that from the people who hold power in the hierarchical system.
Well, and I mean, I think too, you can look to the issue of diversifying the military. I think is a great example of this.
Hmm.
When I think it was Truman who desegregated the military, and of course, everyone thought the sky would fall and the military
Hmm.
would fall apart, and we wouldn't be able to have dominance anymore. And of course, that didn't happen. And then they want, when women when there was a push to have women included in the armed forces. Oh my God, how will that ever be? I mean, there were men and women together, that can't exist, and
Hmm.
women can't fight, and all these things. And of course, we're okay. It's
Yeah,
all
the
it
sky
worked
hasn't
out.
fallen.
But right there,
Yeah.
but there is the sky is falling when there is some major change perceived in the
Right.
order of, in this
That's
case,
right.
Right.
in the order of relationships, right? And that's what people are afraid of. But here we are today. We're still talking about equality in many gender-related subjects, whether it's equal pay, sexual harassment. We're seeing that play out in our politics right now, and in so many other ways. And is this perhaps the time right
Hmm.
now, even though probably many people have figured that either we already have an equal rights amendment or figured it's just a footnote in history, but is now perhaps the time?
I would say yes. If you read now, as it's going to take still some few years, um, but I do believe it was 1982 when that extended deadline Lucy referred to expired. But immediately, the Equal Rights Amendment was reintroduced in every session of Congress since then. And there are now, this is something to get into briefly at least, there are two, I'll call them routes to ratification that advocates are working on. The first
Okay,
is just
tell us about that.
starting over, reintroducing an Equal Rights Amendment in Congress. Representative Carolyn Maloney from a district in Manhattan has been the point person on that and a strong advocate for a number of years now, 20 years plus, I believe. And actually, Senator Menendez from New Jersey has the Senate version of that introduced in this current Congress. But since the mid 90s, there has been a second route, and it is unprecedented. Has got good legal arguments behind it, but it's untrodden constitutional ground.
All right,
And
but
that
hold
is
on a
this.
second, though. Wait, before you
Yeah.
get to the second, let me just finish understanding this first route.
Okay.
So if I understand, the argument here would be, okay, Congress passed the ERA in 1972, but enough states didn't ratify it or vote to ratify it in this time frame that Congress imposed. And therefore, the argument might be that the ERA died. And to start over again, you'd have to have Congress pass it again, and that would somehow start the clock over again for states to step forward and vote to ratify it. Is that right?
Very, very well explained, yes.
Good.
Article 5 in the original Constitution gives you that process. And so if one would say, well, the first process with the ERA didn't get achieved by the deadline, okay, so we can start it. There's nothing that says you can't reintroduce it and pass it again out of Congress, requiring a 2/3 vote in each house, Senate and House of Representatives, and then requiring 3/4 of the states, and with 50 states, that means 38 is 3/4, must approve it. They call it state ratification. And then if 38 states approve it, that satisfies the ratification process, and it's become part of the Constitution. It would be the 28th Amendment, let us hope.
And as you said, and I just again want to make sure this is clear, there is a bill pending in both houses of Congress right now
Yes.
that would do just that. So if Congress would choose to do so, they could vote and pass current bills currently pending in the House and currently pending in the Senate, and then it would be back to the states.
Then it would go
to
back
take
to
up
the
the issue
states.
of ratification. Okay, so
now,
that's the first
and let me
pathway.
and a little final comment on that is, given the way there has been gerrymandering, voter suppression, don't get me started, over the last 10 years based on Republican control of the process in a number of states, state legislatures are more conservative than they were in the 70s. So that would be a process that in theory sounds okay, let's get this done. It would be very, very difficult right now to have 38 state legislatures ratify it. So,
well, yeah,
political.
I mean, to have to start all over again when Congress passed it and 37 states have already voted to ratify it. That would for sure would be a very major resetting of all the effort. But I want to just
it's the clean. It's the most by the book way, let's say.
Well, and we do have elections coming up every 2 years. We have an election coming up in November. People are very energized on all across the political spectrum right now.
Right.
Women are great focus of all the discussions going on right now. What are women thinking? What are this subset of women thinking? What are they going to do? And I just wanted to be clear that there is this issue that if they chose to, they could make an issue.
Right.
Not
and
just women. I mean, women and men, of course, but
sure.
But voters could make an issue, let's say.
Absolutely. And in fact, voters could make an issue around decisions of who goes into their state legislatures in connection with the second possible route to ratification, and that is that you got a few minutes. I will try to make this as short as possible. But in 1992, actually, an amendment went into our Constitution, something to do with Congress collecting pay raises that it votes itself. And that had first been sent to the states along with 11 other proposed amendments, 10 of which became the Bill of Rights, for heaven's sake. It came out of Congress in 1789. And Congress sent 12 things to the states, 10 of which became ratified as the Bill of Rights. two of which didn't get ratified, and this was one of them. And in the 90s, it got picked up again. They accepted the original, I forget now how many there were, ratifications from the 1700s. They added to it to get up to the 38 required, and that's now in the Constitution. The difference with that and the ERA is that, as I had said, we talked about the fact that time limits weren't imposed on ratifications until in the teens. I don't remember. Do you know the year of Prohibition anyway? 1915, 16, 17, something like that.
Mm.
So that time
19.
limits, was it? Okay.
I think it was
Then,
19, right before 20.
It was, yes, it was the 18th Amendment. And then Congress debated and arbitrarily chose 7 years as the time limit they put on that. I say it's like the 7 deadly sins, 7 brides for 7 brothers. 7 is just kind of a magical number.
Right.
And so that was not imposed on the next one that went out to the states, and that was the 19th Amendment for women's right to vote. And that was ratified in 1920 with no time limit attached. And then I don't know the logic behind it, but they decided, time limits aren't such a bad idea, and they have put them in every other one since then. However, sometimes they put it in the words of the amendment itself. If you go read the Constitution, you'll see a few amendments that have a time limit in its words, which of course has no relevance after it's ratified. But anyway, there it is in the Constitution.
Well,
whereas,
let me go back and understand this, because this is really, I think this is not only historically fascinating, but brings to the present the all of what we're talking about. So we talked about the first path to passing the ERA, which basically would be to start over and follow the constitutional rules for how you amend the Constitution. The second path, which is what we're talking about now, is to take all the work that's already been done, the fact that Congress passed the ERA in 1972, and that as of May of 2018, 37 of the 38 required states have voted to ratify the ERA. And in that case, what I guess we would do, and we should talk about the specifics, is we would look for a 38th state to vote to ratify. And then as far as you'd be concerned, the ERA is part of the Constitution. And then there's a but. And the but is that there is this time limit that was imposed.
right.
And then the but to the but is that time limit valid? And what you're pointing to is this
well outlined,
precedent that the what we know of as the Bill of Rights, the first 10 amendments to the Constitution, the First Amendment, the Fourth Amendment, all those amendments that became the Bill of Rights really was sent out to the states as 11 amendments originally, and
12
one
actually,
of them, or it was 12. And the one that that you're referring to, the 27th Amendment, I don't know why it took as long as it took until 1992 for that to be ratified, because it seems like, again, everybody, if you just tell them that this is the idea, they'd say absolutely, which requires that before Congress can give itself a pay raise, you have to have an election intervening, which would, I guess, give people the opportunity to vote out of office anyone who voted for themselves to get a raise. Sounds
That's the
pretty
premise,
reasonable.
although just here's an extra unfriendly footnote. They do it now by cost of living adjustments that they contend doesn't apply, this amendment doesn't apply to, but go on.
Okay. All right. Well, they found a way around it. But anyway,
that's right.
The idea here is that allowing all this passage of time, it was over 200 years from the time what became the 27th Amendment on this pay raise issue became part of the Constitution. It was over 200 years between the time it was sent out to the states and the time that was finally ratified. Now, you're pointing out that back in those days, in the early days of our country, they didn't have a time limit put on the amount of time states would be given to ratify, and they did do that here. But you
have pointed out too that there could be a debate about whether time limits are the ultimate trump card or whether something could prevail over a time limit. As for instance, the need for an amendment or something. It's going to be a very interesting for constitutional scholars and anyone else interested.
But can you
Debate if when
imagine?
that age.
Can you imagine as a political matter, especially in the times we live in right now, if a 38th state, and I do want to talk about who you think that
Oh
38th
yes, I
state
can
might very well
address that.
be, but let's say a 38th state would vote to ratify the ERA, as Illinois did only a few months ago, and
Mm-hmm.
as Nevada did only a short time before that.
Last year, yeah, right.
All right. If a 38th state did so, and now we say, and everybody stands up and says, "Hooray, we have an ERA," but the Supreme Court of the United States, with all the focus that we
Oh
now
yes, bring
have
it on home here.
on the Supreme Court, says, "Wait just a second,
Right.
you're just a little late."
Yes.
Uh, I
Yes.
don't know that I think that would be an incredibly,
Right.
charged,
Right.
politically very difficult decision for the Supreme Court to make. I'm not saying it wouldn't, but it would,
Right.
who knows what might come from that. So,
Right.
all right. So
Yeah. Well, can I
well,
just
go
point
ahead.
out one distinction here? The 35 states, there were 35 states that approved before the 1982 deadline. And so the ratifications in question for challenge, if you will be, it was Nevada last year, it's Illinois in May of this
It
year,
was
and for next year, pardon, Luke? Oh, and for next year.
I was confirming Nevada was in 17.
Oh, yes,
March of
yes.
17.
Oh, thanks,
Yeah.
yes.
Yeah.
Right now, the states with most active advocacy efforts and perhaps most promise, Virginia and North Carolina, with Virginia a little better positioned at this point in the construction of their legislature, a little closer to parity with Democratic and Republican. North Carolina has elections, of course, this year, and there is every expectation it will look better next year, but not necessarily as close as Virginia to having Democratic, input, if you will. And the third is sort of out of left field. If you're looking at a map, is Arizona. I'm joking, but off in the west, Arizona has a fairly active advocacy effort there. There were 15 states, obviously, of 35 ratified. 15 didn't. Right now, 2 of them have ratified since, but their ratifications will be challenged legally in some way or other. And that third state, if we get the 38, there's a whole process. And I would recommend people you can read more about this on equalrightsamendment.org, which is a website that is Alice Paul Institute's ERA website. I have managed it and have information up there. But the FAQ, frequently asked questions page, gives you a lot more background on this if you're interested. Equalrightsamendment.org. There are fact sheets on the homepage that you can link to, and so you can get a lot more information about this. But it's going to be very interesting may you live in interesting times, Kurt. Very interesting to see what happens, because you're right, Aaron. It would be a very, very tense debate decision for the court to say, "Oh, you pat the advocates on the head and say you did really great, but you didn't." There is a law article that you can read, linked to on that website, that explains, I think, very lucidly why a claim can be made that ratifications now, even though there was an arbitrary deadline set, that ratifications now have more constitutional underpinning for their validity than opponents would say. And
so
there's a lot more background.
So we'll post a link to that too, Bobby,
Okay.
on the description,
Right.
so people can just click on it when they go to our podcast episode, and they can click to it. It'll take you right to that website.
Oh, excellent.
So, all right. So, as within the deadline, 35 states voted to ratify the ERA. 15 did not.
Right.
And these are the 15, just so people can hear the names of the states that did not vote to ratify: Alabama, Arizona, Arkansas, Florida, Georgia, Illinois, Louisiana, Mississippi, Missouri, Nevada, North Carolina, Oklahoma, South Carolina, Utah, and Virginia. And then since the deadline, and really in the last 2 years, Nevada and Illinois have joined those 35. So why? Because this wasn't really clear to me. If you had to pin your best hopes on one state to become the 38th, you've singled out Virginia and North Carolina, possibly Arizona, and
Yep.
explain for us why. Why do you think those states may offer the last 38th state on this issue?
Well, 12 of those 15 states have had ERA ratification bills introduced in one or more of their legislative sessions since that deadline. And so Virginia, in particular, has a track record of having introduced it in a number of sessions for the state legislature to ratify it. And in 4 or 5 of those cases, the state Senate in Virginia did pass it, the ratification bill. But Republicans strongly controlled their House of Delegates, and the man who controls the committee out of which the ERA would come just kept a lid on it, never even allowed it to come out of committee for a full floor vote in the Virginia House.
Okay.
Now that House, I don't know if any, Virginia, like New Jersey, has their legislative elections in an odd year. They had them last year. And there was an incredible neck-and-neck battle in Virginia for control of the House, and it ended up down to drawing lots, if you will, to see which party controlled, because there was a mix-up around about notifying voters, giving them sample ballots and such. And so there was a disputed process in 2 election districts. They drew lots. The Republican drew the right little chit out of the hat, and that's how Republicans control the Virginia House. And so, given, as you've referred to more than once, Aaron, the current climate around Me Too, Kavanaugh, et cetera, it may be possible to get it out of the Virginia Senate and House next year. And North Carolina has had a tremendous advocacy effort. They're the one group that set up an ERA alliance. A woman named Marina Grahl and Roberta Madden and various people in North Carolina have done a tremendous job of creating a unified advocacy effort there. And North Carolina's legislature is less marginally Republican and conservative. It's more so. But they still have so much good energy there that that's a possibility. And then in Arizona, they've had bills introduced. Here's a vignette from history. I have a New York Times or Washington Post article, I forget which, right after ERA came out of Congress in 1972. And it quoted in Arizona. Arizona wanted to be the first state to ratify, but because of the time zones, Hawaii became the first state to ratify. And a state senator there was quoted as saying, some of the energy went out of the effort then, and maybe it's only a 50-50 chance now that Arizona would ratify. That state senator was named Sandra Day O'Connor.
Oh, my goodness.
And the reality is Arizona has not yet ratified, but They have a very good effort going there, too. And so even in some of the other of the 15 states, there are good efforts, but these are the ones that we are looking at first and foremost.
Let me ask you, Lucy, looking at where we are, if you were asked, and you will be, because I'm going to ask you right now, what do you think? If people were to hear this and say, "Wow, I want to do something about that. I want to learn more. I want to find out what I can do." What would you say to that person?
Well, I think their first stop should be that equalrightsamendment.org website to learn something about what's going on. Look at our organization, alicepaul.org. Look at the ERA Coalition. There are organizations across the country that are working on the issue of the Equal Rights Amendment. So I think what helps is to give yourself a little education through the websites and then contact the organization that's near you. And we're trying to create here a database of those organizations so that equalrightsamendment.org can be a one-stop shop. You can find out about the amendment and find out about the groundwork going on. We have a toolkit on our website, alicepaul.org, that you can use to start something in your own community. And that's all downloadable toolkit that gives you some materials that help you educate yourself and others around you, and some PR materials as well. So I think there's a lot. I mean, it's just amazing now with the internet how much education we can do without people having to leave their own homes.
Right.
But then the real hope is that they will leave their homes, get involved in marches, get involved in lobbying their congressional reps and finding out what their stand is on the ERA. Our own Girls Leadership Council here went and visited our local congressmen in their Washington offices and put their feet to the fire. You know, are you signed on as a co-sponsor of the ERA? And if not, why not? And these 15-year-old girls really asked for some answers from our congressman about why he wasn't supporting this, what he had against equality. And they've now continued that conversation through his Facebook page, and continue
to remind
of
babes, right?
Right. Yeah, they continue to remind him that, you know, Alice Paul was a constituent in your district. You need to look at this legislation and get on board with it. So they're doing right by their namesake, and really taking it to the people in power, and demanding answers for what they have against equality.
Well, and I've been on the website, both of them, and you're right. There is a lot of material there, a lot of the things we've talked about and more. Why do we need the ERA? What types of issues would an ERA offer better, even more solid protection for? What is that history? What is the background? Where do we stand? There's a lot of information there, and I too encourage everybody to go check it out and learn more.
Could I just add the final
Yeah.
legal issue there, which could talk at length about, but there are different levels of so-called scrutiny that a court applies when they look at a claim of discrimination on the basis of sex or other things. And discrimination claims around race, religion, national origin, like that, get what's called strict scrutiny. It has to be constitutional. That kind of differentiation, discrimination, if you will, has to have a it has to have a necessary relation to a compelling government interest in order to be upheld as constitutional. So you can't make laws around race differentiating between treatment of groups on the basis of race or religion without having it be a compelling government interest that's being served, and what you're doing has to be necessary to advance that interest. Sex is not in that category yet. You can discriminate on the basis of male-female sex, and it doesn't have to be that compelling a connection to a government interest. It can't be just, oh yeah, that's logical, that's rational. It's an intermediate level of scrutiny. It has to substantially be related to an important government interest, but the Equal Rights Amendment would put sex into the category of requiring strict scrutiny in court to be upheld as constitutional.
Right.
And so I think that's really key for people dealing with this legally, to understand that's not just a minor argument. That's compelling, if you will, no pun intended.
Right. It's the ultimate protection to make sure that any law or act or regulation that would discriminate on the basis of gender would have to meet the highest level of scrutiny by our courts, as is applied in cases of discrimination on the basis of race. But also, this, just to wrap up on this, I think to go back to something Lucy was explaining about Alice Paul and why she felt, going back to the early part of the 1900s, when women were still fighting for the right to vote, is the idea that we have a constitution that reflects not only who we are as Americans, but reflects us as a country to the rest of the world. Right. And how is it the case that there are constitutions in so many other countries that recognize this basic principle of, and it, not just talk about it, but it's in your document, it's in your founding document, the Constitution. So many other countries have this, but the United States of America doesn't. And
Right.
it just kind of strains belief at this point that it doesn't.
There you go.
But listen to him; it's true.
Right?
Yeah.
Right.
So there you have it. And it is a fascinating history, but it's also a very current issue. And I hope people will go to your websites and check out what's there and all the information you have. And Lucy Beard and Roberta Bobby Francis, thank you both so much for being on Good Law, Bad Law, and for talking with me about this. I really appreciate it. Thank you.
Thanks for having us.
Too.